Hi, my name is Stuart Weems and welcome to the Investopoly podcast. Our goal is to share easy to understand evidence-based holistic insights to help you master the game of building wealth. And in today's episode, I want to talk about testamentary trusts. And Campbell is going to produce a complementary episode to this around the tax related to super benefit payments, death benefit payments, in a few weeks' time. So we'll kind of cover off these issues, hopefully. But what I wanted to do is talk about testamentary trusts. And well, I didn't really want to. It was suggested that I do a topic. I'm quite happy to, of course, from a listener on YouTube asked me to produce this episode. So I thought it was good. I didn't know if there was going to be enough in it to create a full episode. And surprise, surprise, I can prattle on about anything. So there's plenty of content in here. I think it's a really important episode. Estate planning is something, a lot of people think about quite deeply. It's always on their to-do list. Like, I need to update my will, or my will's out of date, or I need to think about how this is going to work longer term. But it's important, but I hope it's never urgent, of course. But, making sure that you structure your financial affairs so that, your beneficiaries are looked after and it's going to suit them from a taxation perspective, from a financial planning perspective, and protect them, particularly if they're vulnerable beneficiaries, vulnerable people, I think is really important. Now, I've written a couple of other blogs and recorded episodes in regards to wills and estates. One back in 18, that would have been probably before this podcast started, and one in 2020. I don't have the episode numbers because I wasn't using numbers back then, but if you want to go back and have a look at those in terms of just general will structure and so forth, the links are on the blog on the website, and of course the link to that blog is in the show notes. Now, I guess that the starting point needs to be understanding how taxation to minors, so that is individuals that are less than 18 years old, are taxed differently to adults. And it really comes to, it's in respect to unearned income. So interest, dividends, capital gains, investment income, if you like. If they've got earned income, which means they've got a casual job, down at McDonald's or whatever, of course they're taxed the same way as adults, which is really no tax on the first $18,000 to $20,000. But with respect to unearned income, so investment income, the first $416 is tax-free, but any amount over and above $416 is essentially taxed at 47%. There's a couple of, there's another sort of tax bracket in there that's much higher, but essentially your average rate is going to end up being 47%. So there's a really big penalty, I guess, for children investing in the share market or having other investments and generating passive income. And obviously that's structured, just to make sure that parents aren't using their children as a tax haven, and trying to minimize tax that way. Now, there is one important exception, however. If a minor receives income because of a will or through a testamentary trust, that income is, the income the assets produce, or taxable income and gains that those assets produce, are taxed at normal adult rates. And this income is called accepted income. So in other words, the child can benefit from the $8,200 tax-free threshold and not pay any tax on those monies. Now, this tax exemption, or tax treatment, I should say, isn't exclusive to testamentary trusts. So, if I have, my kids are over 18 now, but when they were less than 18, if they had received an inheritance from a grandparent that had passed away, for instance, and I invested that money, then of course they would benefit from those lower tax rates as a result of that inheritance. So if you don't need a testamentary trust to get that tax benefit, why would you have one? Well, that's what I'm going to spend the rest of today talking about. So I'm going to talk about what a testamentary trust is, why do people include them in their wills, and some practical uses of testamentary trusts that we've been involved in. So, I think it's great to conceptualize these things, but you kind of want to know, how does it work in practical terms in the long run? So let me start with kind of defining what a testamentary trust is. So a testamentary trust is really just a discretionary trust that is established via a person's will. So it doesn't exist until the person passes away. The trust deed, which are the rules of the trust, is included in the will itself. So you don't have a separate trust deed, it's just the will, and that becomes really the trust deed for the testamentary trust. Just like any trust structure, there is a trustee and then there are beneficiaries. The trustee, typically the executor of the will, but it could be anyone else. Doesn't have to be the executor. Could even be the primary beneficiary, for example. They could be both the trustee and the beneficiary. And it can even be a company if you really want it to. Most testamentary trusts provide very broad powers, but it really is up to the trustee. And so you can write a deed or instruct your solicitor to write a deed in any way that you would like. So it might have very restrictive powers or very broad powers. There's no standard here. But really, to use it to its greatest extent, you want to have really broad powers, which means that the trustee has the discretion to distribute income and capital to a wide range of beneficiaries, and that they can distribute different types of income, say franked dividends versus capital gains, also to different beneficiaries. Really, what you want to do is give them the widest kind of landscape, if you like, to make the best taxation decisions at that particular time. In a will, it can stipulate that one testamentary trust is created and that is to be used for all beneficiaries, or a better option, the will can state that multiple testamentary trusts can be created so that each individual beneficiary can have their own testamentary trust. That's much better so that you're not mixing assets. So for example, in my situation, that's what my will says, we can create two testamentary trusts, one for each of my sons, rather than just one trust for both sons. They're going to be different age, state, well, they're not different ages, they're twins, but different stages of life perhaps, and want to use the money differently. And so it makes sense to put it into two different testamentary trusts. But essentially, we can just think about it like a discretionary trust. It's not much different to that. Now, I think when it comes to estate planning, and particularly if you're looking at your, pretty sort of generic situation where you've got mum and dad, they've got a pool of assets, mum and dad have some children, could be one, could be many children, and they want to leave most of their wealth to their kids. In that situation, statistically, the biggest concern from a financial planning perspective is probably relationship breakdowns, and particularly when you're drafting a will when your children are not yet in a long-term established relationship where you can kind of make that assessment, or either the risk materializes or becomes lower just because of the presence of that long-term relationship. So when you think about it, what you wouldn't want to happen is that you pass away, all your estate transfers to your child's in an unhappy marriage that subsequently dissolves, and 50% of those monies then go to your child's ex-spouse. Now, in that situation, some people go, well, that's just life. It is what it is. In other people's situation, other people become very concerned about that. So it's not for me to dictate to you, the listener, whether you should be concerned about that, but it's really just about that's probably statistically the biggest risk. We'll get into at-risk beneficiaries in a second, but that's probably the biggest risk. And if you are concerned about it, then there are things that we can do, or that a lawyer can do, to sort of structure a testamentary trust to protect you from that risk. So one of those options is to create what they call a bloodline testamentary trust. And that essentially means that the only people that can be beneficiaries of the testamentary trust are bloodline relatives. Now, we forego a bit of flexibility here. Whilst we gain some asset security, we lose a bit of flexibility, because it means that, for example, if your child, your bloodline beneficiary, is in the highest marginal tax rate, they have no children, and your child has a spouse that has no other income, then of course in a normal world we would want to distribute to the non-income earning spouse. But when we have a bloodline testamentary trust, we can't do that. So it protects you. There's a cost associated with it. A more flexible arrangement could be to have a testamentary trust where there are two classes of beneficiaries. The first class of beneficiary are beneficiaries that are not in a relationship, married or de facto, or are in a relationship and have a binding financial agreement. Typically they're called prenups or postnups, and that binding financial agreement specifically excludes any capital distributions from the testamentary trust to be not included in the marital asset pool or the relationship asset pool. So they're the two classes of beneficiaries. You're either in a relationship, or if you are in a relationship, so that's the first class, you're in a relationship, or if you are in a relationship, you've got a BFA. The second class of beneficiary could be in a relationship but with no BFA. And so what the testamentary trust could say is that if you're in a relationship and you don't have a binding financial agreement that excludes the capital of the trust, then all you can get is the income on each year. And the capital is then preserved or locked into the testamentary trust. On the other hand, if you want to access capital, then you have to execute a binding financial agreement that, as I said, specifically excludes that capital distribution from being included in any relationship asset pool. Now, again, it's a more complex arrangement, and again, some people might not be that concerned about it, but I think if you were concerned about it, or you had a child that had a relationship that you didn't think unfortunately had a lot of longevity, then these are the sorts of things that you might want to think about in terms of structuring your will and structuring a testamentary trust to give you some protection. So let's talk about why people establish a testamentary trust, because as I said at the start, the tax benefit associated with the investment income related to an inheritance isn't exclusive to a testamentary trust. You can achieve that same tax benefit if you didn't have one. So why do people establish testamentary trusts? Well, I've got a couple of reasons, and I'm going to talk about them in a second. But essentially, you would consider a testamentary trust if you had substantial assets in your personal name. So don't worry about a company or trust. I'll get to them in a second in terms of how they're dealt with in an estate planning matter. Superannuation is not part of your estate. The superannuation trustee, the trustee of your super fund, needs to decide where to pay that. And if you've got a bonding death benefit nomination, they'll have to comply with that. So it's really just if you've got assets in your personal names. And the more assets you have in your personal names, the more likely you'll need a testamentary trust. Now, if those assets are property and they're held jointly, you don't really need to worry about it, because when you pass away, the remaining ownership of the property will pass to the surviving joint tenants. So it's not part of your will. But if you own property as tenants in common, of course, if you're the surviving spouse, you will need to worry about it. But if you've got a surviving spouse, it's not going to be party to your will. But that's the key thing, is what's the value of assets inside our personal name. Okay, so let me talk about the reasons then. So the first one is tax efficiency for minors. Yes, you can get that without a testamentary trust, but having a separate entity, that you establish accounts in this name, it just makes record keeping really clear. It makes it really obvious in terms of what assets are related to that inheritance. And particularly if it's a large portfolio of assets and we're buying and selling investments, it can be difficult then to track unless you've got a completely separate account. So having it all in sort of one entity keeps that record keeping really clean and ensures the tax benefits are fully preserved. The next one is the flexibility around the treatment of taxation liabilities. So that means, because the testamentary trust acts like a discretionary trust, we can optimize the distribution of any income or capital gains that occur in any particular financial year as tax effectively as possible. Also, it allows us to manage a pool of assets all in one place because, for example, the beneficiaries might want some capital now, but they might like to leave some investments remaining. And so when you've got a pool of assets rather than leaving individual assets to people or in an estate that needs to be wound up, you can potentially sell some assets, distribute some income now, and then keep some assets maybe for the future for whatever reason in this entity, and you don't need to be forced to make a decision. Whereas if you've got an estate, you typically have to wind that estate up relatively quickly, like a couple of years, 2 or 3 years, but you can't necessarily just say, look, I'm not going to wind the estate up. We're going to keep this, this holiday house that has some sentimental value, for example, just in the estate, and I'll do the estate tax return, all those sorts of things. Unfortunately, you can't do that. You don't have that flexibility. So it does give a lot more flexibility for the dealing of assets, particularly in a situation where you're not going to just sell everything and split it and go your separate ways. There are some potential asset protection benefits because the assets are held by a trust, not individuals, and no one's entitled to the assets until the trustee makes that election. You've afforded some protection then from creditors, legal disputes, bankruptcy, and even potentially family law claims as well. So it does give you some asset protection. And if you've got beneficiaries that are younger, particularly below 18, but even maybe in their 20s. It gives you, the ability to kind of control the use of capital. So, for example, you might say in the testament trust or in your will that your beneficiaries, can access capital for education, for medical needs, or maybe a first home deposit, but nothing else until they're, say, 25 or 30 or whatever you want it to be. And that way you can structure your will so you're not going to necessarily just give a whole bunch of money to someone that's just turned 19, for example, that has no idea what to do with it and then might end up making some silly decisions. In that way, because you've got the assets in a pooled entity, you can kind of control through your instructions of how that capital and income is to be distributed and used over time. So they're the common reasons for a testamentary trust. It doesn't cost a lot of money, a lot of additional money to establish one, to put one in your will, maybe a couple of $1,000, but the flexibility and the advantages can be worth many times more that. Of course, you will never benefit from that, but of course your beneficiaries could. So when I've got a substantial amount or got a client with a substantial amount of money in their personal names, definitely almost always want to include a testamentary trust. Now, I'll get into some practical uses of the testamentary trust in a second, but I quite often get asked, can you use a testamentary trust for other investments as well and benefit from the taxation benefits? Well, yes, you can, but your taxation benefits are diluted. So if you have a testamentary trust, let's say you establish a testamentary trust, has $1 million worth of assets. If that's all it ever has, so you don't contribute any more into that testamentary trust, then any minors will get the full tax benefits in terms of be taxed at adult rates. However, if I say, okay, I'm going to use that $1 million and I'm going to go and buy an investment property, the testamentary trust is going to borrow $1 million. So we'll buy a $2 million investment property. Well, in that situation, the income that comes out of that testamentary trust will be apportioned. And the ATO will say, well, half of it was from inherited funds, half of it is new borrowed funds, new funds that are introduced. And so any minors that receive taxable income from this trust will get 50% of the benefit, for instance. Same if I contribute my own capital. So if I had $1 million in there and then put in 200,000 of my own money, so there's 1.2 million in the testamentary trust, again, proportionately, the ATO is going to look at it and proportion the tax benefits. So for these reasons, we typically recommend just quarantining that capital and not messing with it. So being careful about, and I'll talk about this in a second, being careful about whether you withdraw money from that trust, because once you withdraw it, you'll lose that potential tax benefit, but certainly not introduce any new capital, be that via borrowings or any contribution for yourself. Just quarantine it and leave it alone. Okay, so as I said, let's talk about some practical uses of a testamentary trust. Because, once you sort of understand how you might, or how your estate might use it, or in fact how they could carry out your instructions, it puts some more meat around, why these things exist and why some people have them in their wills. Okay, so the first one you could use as a intergenerational education fund. So, for example, you could choose to put either a portion of your estate or your whole estate into a dedicated testamentary trust specifically designed to fund education costs. Could be private school fees, could be limited just to secondary school or all schooling, could be university fees. There could be clauses in there to say like, we'll reimburse on successful completion of the course rather than just necessarily hand out the money. But, you could come up with your own ideas around that. And depending on the amount involved and assuming it's prudently invested over time, a trust like that could potentially educate many generations. And, education, there's a big correlation between, health and wealth and education levels. So, it could be something, a contribution that you make towards future generations that you might never have anticipated. But so you could use a testamentary trust for that. Now, one of the challenges is that testamentary trusts, and any trust really, that are established outside of South Australia only have a 80-year life. So that's the maximum that a trust can exist for. And at the end of that 80-year period, all the assets must vest to the beneficiaries. So unless you have the closest and most substantial connection to South Australia, which really means all your assets, you live in South Australia and all your assets are there, you then need to consider how that's going to work, because you could have one generation that doesn't spend much money on education and the next generation does, but you might get to a point where the 80 years are elapsed and then really the money hasn't been used much, and that particular generation then benefits. So what you might do is say, okay, we're going to pay for education, but at a certain age, these beneficiaries will then be entitled to a certain share of the assets. And so then you can think about, well, if I need to fund 3 or 4 generations over that 80-year period, my goal is to make sure the money's fully utilized over that period of time. Anyway, it gets a bit complex, but something that you can speak to your planner or lawyer about. A testamentary trust is great for supporting at-risk beneficiaries. So an at-risk beneficiary is one that needs sort of greater oversight. So for example, individuals with addictions like gambling or alcohol, those with really poor financial judgment, people living with disability, these sorts of cases, a testamentary trust can be structured to, provide modest regular income distributions, limit large sum distributions, for example, and just ensure that the person's money is supported and invested well and isn't exposed to any undue risk. So if you have any beneficiaries that kind of might fit that bill, then, a testamentary trust, and if you've got a child or beneficiary that has a disability, could even have a disability trust involved as well. Could be a way that you can support that individual in a better way than just giving them a lump sum of money. Certainly as a tax saving mechanism. So one of our clients received unexpected significant inheritance, and they're lucky enough to have 7 grandchildren. Last financial year, the Testamentary Trust recorded about $240,000 of income and capital gains, and we distributed that amongst the 7 grandchildren as well as some to the individuals as well. And because of franking credits, each grandchild got around about $2,000 back in terms of a tax refund. So really, the Testamentary Trust earned $240,000 of taxable income, and the total tax refund was $12,000 on that. So it's pretty tax effective, right? Like, you're not paying any tax. In fact, you're getting tax back because of franking credits. So it can be a really effective mechanism for saving tax. Now, if your wishes include donating some of your estate to charities, then a testamentary trust together with a public ancillary fund could be a really great way to sort of structure your will. So a public ancillary fund is a fund that is able to accept donations and is a deductible gift recipient, which means that you can claim a tax deduction for it. Now, the thing you need to think about, the things I think about are, look, if I've got a big estate and I want to say, look, donate half of my estate to charity, you need to think about when will that be done and how will that be done? Because, if you're donating a substantial amount of money, then the risk is which charities are you going to pick, and are you going to give them all that money in one year? And if the charity stops doing good work or the kind of work that you anticipated they were going to do, that could end up not being as effective as possible. Secondly, if you've got other assets, so for example, in my situation, of course, I've got investment properties. Now, my wife and I passed away today. I wouldn't want our sons to go and sell those properties. Firstly, I don't need the cash yet, and you may as well, keep the process of investing working. We do have instructions to donate a significant proportion of our estate to charity. So how my will is structured is to say that use a public ancillary fund. You don't have to make the donation straight away. You can choose the timing of the donation so that it's tax effective as possible. And the benefit of a public ancillary fund is you put the money all into that fund, you get the immediate tax deduction, and then you can give that money away over time. I think you've got to give between 4 or 5% per year to charity, but no more than that necessarily. And so that means that I pass away today, the boys do nothing, they hang on to the investment properties, let's say they sell a property in 10 years' time. They then go and make a lump sum donation to offset the capital gains tax. And that goes into the public ancillary fund. And then they donate 5% of that balance every year for the next 20 years, for instance, or probably the next 30 years. And it teaches them the satisfaction of donating to charity and helping people beyond yourself. But it's also really tax effective in terms of the timing of making those donations to offset any taxation consequences of selling assets. And then also limits the risk of of, donating a whole bunch of money all in one hit to one particular charity. In that situation, when you're posed with the decision which charities, it starts to become a much bigger decision than it really probably needs to be. So it just depends on your wishes, of course, but a public ancillary fund together with a testamentary trust can really achieve some good tax outcomes, but also achieve some good outcomes in terms of executing your wishes as well. Another way you can use a testamentary trust as a source of borrowed funds. So, for example, people that inherit monies, say in their 30s and 40s, might want to use those monies to reduce debt or upgrade their home. Like that's a kind of a common situation. They're either quite heavily indebted from a non-tax deductible perspective, so from a home loan perspective, or they wish to be quite heavily indebted by upgrading their home. So in that situation, if they receive an inheritance, the natural and probably best use of it is really debt reduction. But that's in the short term. But in the longer term, they really do or would like to utilize the benefits of having a testamentary trust in place and accumulating monies in that testamentary trust, not only for their own retirement, but also potentially to benefit their beneficiaries. So one way that you can use the testamentary trust then is a source of borrowing. So instead of distributing out of the testamentary trust, distributing a capital distribution, the client borrows, or my client borrows from the testamentary trust. And that means we create a loan. There's a loan agreement. And it means we create a loan between the testamentary trust as a lender and the client is the borrower. They can then put that against, put it in their offset account or use it to upgrade their home or whatever they want to do. And then when they're more established and they've got a better surplus cash flow, what they can do is gradually repay the loan back into the testamentary trust and reinvest those monies. So if you've got a testamentary trust that includes multiple people, so you've got multiple siblings, well, you're going to have to do that on a commercial basis potentially. Unless all siblings want to do exactly the same arrangements, then you probably don't need to charge an interest rate. But just be really careful about, if you have a testamentary trust, making a capital distribution, because once it's out of the trust, you'll never get it back in there again in order to get the tax benefits, and that's something that you might regret in the future. So there you go. That's more about sort of testamentary trust, why they're used, and some practical elements. The next bit I wanted to talk about is handing over control of entities, because you might have entities such as companies or trusts. And that's a common question I get is how do they fit into the framework in terms of estate planning and wills? So if you've got these sorts of entities, you might say, okay, I'll put a testamentary trust in my will because, I've got my home in my personal name, maybe a couple of investment properties, whatever it might be, and that'll be dealt with. That'll all go into the testamentary trust or testamentary trusts as in multiple. Then if I've got a family trust or a company, then I need to think about that. So with trusts, the key person is the appointer. The appointer is the person or party that can replace the trustee, that has control over who the trustee of the trust is. And so assuming your deed permits it, and most modern deeds do, the control of a trust, and that's all you're really doing is handing over control of the trust because no one's entitled to the monies yet. So there's nothing to hand over in terms of ownership, but it's really control of that pool of monies. You typically do that by nominating a successor appointer in your will. And as I said, that appointer, that's the key person because they can control the trustee or replace the trustee if they need to. So that's done in your will. Now, if you've got companies, well, the shareholding doesn't really change. If the shares are owned personally, well, they will go into your estate and then potentially into the testamentary trust, depending on what your instructions are. If they're owned by a family trust, well, you just hand over control. So that's just the shareholders, but really it's the directors of the company that really control the company. They exercise the day-to-day control, not necessarily the shareholders. Now, most company constitutions dictate what happens when a director passes away. Some constitutions may allow you to nominate a successor director, and that would be probably the ultimate thing to do. If the company only has one director, the legislation allows your executor to appoint a replacement director, but ability to do so needs to be in the company's constitution. Alternatively, you can draft what's called a company power of attorney, and that allows someone else to act on your behalf to manage the company if you become incapacitated or you die. But you're going to need to really think about, how do you replace yourself as director in the event of your death? And you need to look at the constitution and maybe consider a company power of attorney. Okay, let's talk quickly about superannuation. Superannuation doesn't automatically fall to be part of your estate, doesn't necessarily go into your estate. In fact, the trustee of the super fund needs to decide who to pay your super benefit to, and this decision is typically guided by your death benefit nomination, which could be binding or unbinding. It just depends on the super fund that you're dealing with. But obviously you want a binding death benefit nomination so that the trustee is bound to follow your instructions. You can have a death benefit nomination that nominates your personal legal representative, which essentially means that you're going to put the money into your estate. So it'll come into your will because your personal legal representative is your executor of your will. If your super is paid to certain beneficiaries, it's tax-free. And those beneficiaries are tax-dependent beneficiaries, which is a current or former spouse, children under the age of 18, someone who is financially dependent on you, or someone that is in an interdependent relationship with you. If they fall into any of those categories, it's tax-free. So it's really, if you leave your super to your spouse, tax-free. Leave it to the kids and they're under 18, still living at home, it's going to be tax-free. If your child is even over 18 but still financially dependent on you, of course that's going to be tax-free. If you have a disabled child, for instance, that is not only financially but is interdependent on you, that's going to be tax-free. But outside of that, and the common one is leave it to children that are adults and that are independent adults, it's going to attract some tax. And typically your balance is made up of a taxable component and an untaxable component. So the taxable component is the only bit that's going to be taxed, and typically at a flat rate of 17%, including the Medicare levy. We call this the super inheritance tax because it's like a quasi-inheritance tax. Anyway, at the beginning of next month, on the 1st of October, my colleague Campbell is going to record an episode on how you can structure yourself to avoid the super inheritance tax, which obviously complements this episode because it's really around treatment of assets in personal name, which go in testamentary trust, and then how do you deal with entities. So just to wrap up then, your will needs to be as simple as possible, but not simpler. Like, I'm not looking to create any more complexity than you really need, but having a really simplistic will won't necessarily give your beneficiaries the widest possible means to optimize their situation. And sometimes, we've got clients that have wills that aren't perfect, and it can be a bit frustrating, to be honest. Because we know what is possible, but in their circumstance, the will doesn't allow it. A good financial advisor should be able to talk to you about, some of the things that you need to consider and how they would structure the will, and just at a sort of a broad sort of strategic perspective. But when it comes to actually drafting the will, of course, you need to engage an experienced estate planning lawyer, because ultimately you want these things to be drafted well. Particularly, you want the terms of the testamentary trust to be drafted well to give you that maximum flexibility. So it's really just a bit of a group effort between your financial planner, and hopefully they can refer you to a good estate planning lawyer that it does a good job for a reasonable price, and ultimately that's how you're going to end up with a good will, I think. Okay, so as you can see, there's plenty of information in this one today. I thought when I sat down to write the blog, I thought there's probably not much in this, but actually there's a lot in it, and it's a really important topic, and I hope that's been useful for you. Okay, next week I'm going to talk about a measure that I've just invented or dreamt up called return on borrowing capacity. The thesis is that borrowing capacity is your scarcest asset as an investor, and so you want to make sure it's allocated in a way that's going to give you the highest return. Anyway, I'll join you next week for that. Cheers. Just a few things before we wrap up, if I may. Of course, you can send me questions at questions@investopoly.com.au. But for a quicker response, feel free to add a comment on the episode's video over on YouTube. We have an Investopoly YouTube channel, and the link is in the show notes. I'm incredibly grateful for the 4.9 star rating on Apple with over 400 reviews. Thank you so much. If you can leave a review or rating, I'd love it, because I'd love to get over 1,000 reviews. That's kind of my target. Keep checking the show notes for free downloads, and I include book discounts there as well. And of course, if you're interested in working with my team and I've included a web link where you can find out a little bit more about what we do and get in touch with us. And of course, until next time, bye for now.